Hey everybody, welcome to the latest edition of Take 5. And today I want to talk to you about a topic around hiring investigators, determining mandates. It's a little bit of a hodgepodge of things that I want to talk about related to a recent case that I read about, a case that was recently summarized by Weir Folds in one of their newsletters. I want to give credit to them. They in fact put this out in, I believe it was August of 2023. It was talking about a matter related to a case that went to court, Rutledge v. Markhaven, Inc., where the court awarded bad faith damages because of an improper investigation. So I read this article with great interest because one of the things that we see a lot in our work is bad investigations, or employers perhaps venturing down the wrong path in terms of how they're about to initiate an investigation, who they're going to hire. And we often find ourselves coming in and frankly cleaning up the mess. Of course, I always joke with my colleagues that I never want to see our name in one of these articles that talks about how something wasn't done right. And thank God 20 years in, that hasn't happened. And it probably never will. But, there's learning for everybody here. And this isn't about criticizing any particular individuals. It's about really just learning. And so what was learned from this? Well, this particular matter, again, as summarized in this Weir Folds article just a few months ago, had to do with allegations of an inappropriate sexual relationship between a leader in the organization and somebody else who received promotion, and there was lots of controversy. I'm not really going to talk a lot about the details of what was investigated. It was these few core pieces that really created a problem. And one of them right off the bat was who was retained to do the investigation. It's really important if you're going to hire external investigators. I mean, number one, they need to be competent. And I'm not speaking to the competency of these investigators. I don't even know who they are. But that is a consideration. Anytime you're going to hire an external investigator, it needs to be somebody who's competent, who has a history. Make sure you've looked into whether or not they have a track record of doing these kinds of investigations. Can they demonstrate their competency? It isn't, there's tons and tons of people out there that are calling themselves investigators that maybe practice a different profession and suddenly hold themselves out as, oh, we can do this kind of investigation, that kind of investigation. You got to stay in your lane. If you want to be good at something, do a couple of things really well. This is why in our world today, in all professions, we see greater and greater specialization, because as things become more complex, obviously people have to become really adept and knowledgeable in a specific area. So like, for example, in our company, we don't do investigations of intellectual property theft, for example. It isn't our bailiwick. It's not something we're expert at. We do professional regulatory investigations and workplace investigations, which actually have quite a bit of overlap. They dovetail quite beautifully. And we've been doing this now for, like I say, 20 years. So that's our area. That's what we stick with, and probably is the reason why we haven't been profiled in one of these articles or found ourselves in court defending ourselves against allegations of impropriety or incompetence. It's really important that you do that. Now, of course, I'm ranting a little bit. What was the key issue here? The key issue here was that there was a relationship that existed between the organization hired to do the investigation and a legal counsel for the organization that hired them. Now, what kind of relationship that was, I don't know. Clearly, the courts ultimately took issue with it. I mean, obviously, we're going to have relationships with different law firms. All of us do. We all refer people that we know are competent and we've had working relationships with. But that working relationship has to be clean from the perspective that there's no conflict of interest. In other words, the work of an investigator is always about neutral, fair fact-finding. Process is fair. Outcomes are fair, biases are checked at the door. This is one of the key reasons you hire external investigators, to avoid any accusations that there was some kind of a bias or some kind of a decision that was made either as part of the investigation or related to the outcome of the investigation that perhaps wasn't focused purely on the evidence. And we never want to find ourselves in that situation. In this case, that due diligence doesn't appear to have taken place, and as a result, the courts took issue with it. Now, other things that are important: mandate. Understand the mandate from the outset. Again, in this case, the mandate, they fell into a trap of what I like to call scope creep. In other words, the scope of the investigation creeped out into other things that really weren't intended or should never have been intended to be part of the investigation. And if they were intended, or if it was discovered that they should be investigated, well, then there's appropriate notifications that should happen and appropriate discussions that should happen so that individuals are given a fair opportunity to answer to and deal with whatever it is that's been discovered or any new issue that's going to come up. So that was another problem with this particular matter. The point here is that when you're going to do an investigation, you have to find an individual who is competent, who is free of conflicts, who will do the job the way it's intended to be done. And in this particular case, that simply didn't happen. There were other issues that were brought up. There was concerns about confidentiality, that perhaps information that was shared by the investigators was inappropriately shared. These things are always confidential matters. And, yes, again, an expression I often use is to make an omelet, you got to break some eggs. What do I mean by that? Well, yes, occasionally we do have to share information appropriately so people can have context and understanding so that they can provide relevant information. But there's a limit to that. There's a way to do that. We make sure everybody involved is bound to confidentiality agreements, and we share only what needs to be shared reasonably for a person to participate fulsomely and provide information that makes them useful to the investigation. So, again, other concerns were raised, such as the issue of coercion and intimidation. Now, the details of that I don't know, but as I've always said, investigators are not about coercing people. We're not about intimidating people. We're about working with people to give them fair and equal opportunity to share information. We have to treat them with respect, and we have to build a rapport of trust. And if we're not doing those things and we're treating people in a manner that creates an unfairness, then obviously that's a problem. So I bring this up and I share this because I think this is a fairly recent case. I believe the investigation or the matter went to court, I believe, in 2022. This reporting came out, as I say, in I think midsummer 2023. It's a great little review that's worth probably taking a look at. Again, it was Weir Folds that put this particular article out. And I encourage you to take a look at it. We can all learn from these things. Again, not about drawing criticisms to the extent of being hurtful to people. It's about all of us learning and growing and recognizing the importance of the work we do and how we do it and how we can be held accountable if we don't do it well. So with that, I'll end it there. Thanks again for listening, and we'll see you next time on Take 5.